the provision of the Constitution. So I think that we should rather be excited that such petitions are coming. But much as we should be excited, we should also not be conclusive to assume that whatever the petitions have stated are obvious. Now the work is on the head of the CJ, right, to establish whether indeed there are questions for this affected person to answer. And once that is established, then the process will actually take off.
Arafo esan so ehyiehia biom. Enti EC boss Jane Mensah the petition. Yes, petition bako 10. And I could do a mampeni mahama ho. Now people are looking forward say petition na kono ombeshe na umweyi no. Now the latest update are na batches o mampeni mahama babe forward petition no edi akwa the new chief justice eye Paul Bafuboni. Na Ghanaians are a bit confused. Amanfo bisa say na adenti no mampeni mahama petition ekodi ne nsa na afi no sign de kwakoma chief justice. No explanation. And a one legal practitioner ere ababetuja echre senior systematically ebano emremu a omofa so eyi obi efi ni position mu say na ebe kaya before mu yi chief justice ye na ehu se be back and forth petition bi koye e ma no bedani nsensem pi yes sa no mo de ba be EC boss Jane Mensah now the forward amagile me pese beti nsem a legal practitioner we dey abetuja ocheche mu se omampeni mahama ni tumi no ontumi nsori keke empamu chief justice no empamu EC boss Jane Mensah just like that. So obi wo mo so nyesa adwuma na it should be some nobody but the new chief justice. Now they show video we say
we have Ghanaians in this country who have the country at heart and want to ensure that public officers are held responsible for whatever services that they provide or for which and whatever offices they occupy. My brother, if you look at Article 23 of the 1992 Constitution, it clearly states that as a public officer or administrative officer, whatever decision that you take, whatever task that you perform must be capricious, must not be capricious, must be reasonable. So once a Ghanaian is of the opinion that another Ghanaian who is supposed to protect the interests of another Ghanaian and by upholding the interests of the Constitution is very mandate, the law allows that person should be brought to book. In other words, that person's work should be tested to ascertain whether the way he or she operates is in line with the provision of the Constitution. So I think that we should rather be excited that such petitions are coming. But much as we should be excited, we should also not be conclusive to assume that whatever the petitions have stated are obvious. Now the work is on the head of the CJ, right, to establish whether indeed there are questions for this affected person to answer. And once that is established, then the process will actually take off. So for me, as a legal practitioner and as a Ghanaian, I am very happy that we have gotten to a stage where Ghanaians know their rights and they are assuring that their rights are respected.
You say this is not a foregone conclusion.
No, it's not.
Okay.
It's not, because as it is right now, you and I, we don't know the content of the petition. All we do know is the fact that the constitutional provision is clear on what the requirement for the removal should be. But as to whether those requirements that is stated in the Constitution, these current petitions have met the threshold, is something that we cannot actually defend until the final report is at. In fact, as we talk right now, it is only the Chief Justice who is robed with the powers to say that based on what I have, placing the interpretation of our constitutional provisions, I am of the firm belief that the affected person has a question to answer. And once that is established, the process is triggered. But if the CJ feels that no, there's nothing in, they are just hot air, the petitioners are just being emotional, the CJ will say that there's nothing for them to answer, and therefore the committees will not be constituted.
I see. Is there room within this constitutional provision for someone, because the suggestion has been made?
Teacher me say, Ebano banche pa banche ohoi, eso on faso papa, yetiminya gari, yenya fufuo, yenya nneema bebrebe na ne di free banche mu. Enti Professor Emmanuel Yaoviche me say, eye banche ohoi, siese de ani ko pa sika o my Ghana, yebetimi enya ede afi eye banche, de banche yemu no.
These two officers to answer, then the CJ will constitute a committee per Article 146, 3, 4, and 5, will constitute a committee per, against Section 15 of Act 959 of 2017, will have 90 days, like 3 months, to go into the merit of the matter, invite all parties, and then at the end of the day, a report will be generated. Once the report is ready, the report is given to the president again to act upon it. And all the president does is to announce what the recommendation or the report will say. So at this crucial time, His Excellency's hands are tied. He cannot do anything. All he has to do is to refer the matter to the CJ. So the main work now is on the table of the CJ.
I see. So you're saying, so you also believe in a conveyor belt theory, because there are those who also think that at least the president should be able to look at the petition and see if it is worth the time of the state before moving into the CJ. You think that should not be the way it should go at all?
No, it's see where we are now. It's not about what I think. It's not about what you think. It's about what the law says. All right. Now, the law says that if it has to do with the removal of the Chief Justice, the Article 1466, then the president is robed with the powers to establish, in consultation with the Council of State, to establish a prima facie case. Now, once it is not about the removal of the Chief Justice, but it has to do with the removal of the Justice of the Superior Court, the president cannot do anything. And once the president trends on that ground, then issues of constitutionality will catch up with him. So as we see where we are right, it's about what our law says. And like I indicated or intimated earlier, Article 146, 3, 4, and 5 will clearly state that if the petition that is received by the president has to do with the removal of the Justice of the Superior Court, the president cannot do anything on that petition than to refer the petition to the Chief Justice to do his work.
So at this point in time, the president has no hand in what happens next.
If the president does and tries anything, he could be cited for matters of impeachment. He could be cited for impeachment because then he's he's looking down upon the Constitution. He's taking powers that he does not have, because these are matters of law. And in the 1992 Constitution, the Constitution is clear as to what to do when it comes to the removal of the Justice of the Superior Court. And it is not within the mandate of the president to establish a prima facie case. In fact, all that the president has to do is he receives the letter, whether they are in envelope or not, and then he receives he sends the petition to the CJ to open the envelope and say, okay, my learned colleague Kisi Ajaben. So the CJ takes it from there. Now, all the president does right now is to wait. When the findings are complete and the recommendations or the reports are sent to him, all he does is to work as the work you are doing now, to declare what the recommendation says.
And you said the grounds are stated misbehavior, incompetence, infirmity of mind?
Yes. And interestingly, what you have stated is a constitutional provision, right, in Article 146, 1. And then when you come to the Act 959 of the Special Prosecutors Act 2017, Section 15 clearly states that, and these are also grounds. It says the office, the special prosecutor cannot be removed except, and the except simply means that ordinarily he cannot be removed, but his removal process can be triggered if he has to do with incompetence, if he has to do with where he doesn't have the capacity, if he has to do with where health-wise he's not in the brain, if he has to do with misbehavior, then the process can be triggered for his removal.
So it also suggests that if I have a petition and I send to the president for the removal of the chairperson of the EC or her deputies, I must be able to establish that whatever issues I raise in that petition fall within the context of stated misbehavior, incompetence, or infirmity of mind. Absolutely.
So there are 3 or 4 grounds per the 1992 Constitution, for 146, 1. It says that you cannot just jump and go there, but you should be able to meet that threshold to say that you are saying that, like in the instance case, you are going to the president to say that, well, Jean Mensah is not competent enough because of A, B, C, D. Jean Mensah has misbehaved because of A, B, C, D. Jean Mensah is not medically fit because of A, B, C, D. Now, when you are able to, as it were, cross that bridge, you put down your petition. Now, when the petition is sent to the president and same is forwarded to the CJ will also take the same words that you have used or petition that you have sent and examine the petition or the words and see indeed whether what you are alleging is something to go by, and if in the opinion of the CJ he feels that there is something for the special prosecutor or the electoral, the EC chair, then he will establish the committee to go into the merit of the matter.
In that for social video no share dear kwa papa na ba be explaining the kama e dia mai na yin him say before the NDC will come to power na omwedika ka to ho because I remember say Honorable Johnson Esirun Ketia making it clear say easy boss Jane Mensah e kon fa so ye ne nyoma no omu nhye da husu yie nti omu bo mmesesa no na omu ka sa no ya hwe enim and they are 12 months or exactly a year omu yi ni mfi ho and na magana for started the petition ko say ane e wo so mu yi no because what is nsem a na legal practitioner na ka na say Ghanaians are happy say petition na eden eko woje ho sen ma mi wari nso comment ni mu unsubscribe here you do your best to subscribe, turn on the notification na share video no for more updates.